Next, we have In re Lutz, Fritz Furman appearing for appellant, and Neil Cooper appearing for appellee.
All right, Mr. Furman, would you like to reserve some time for rebuttal?
Yes, please, Your Honor. I'd like to reserve 4 minutes.
4 minutes. Go ahead, please.
Thank you, Your Honor. May it please the court. In this case, the default, there was no default. Those attorney's fees needed to be added to the principal per the note.
Before we get into that part, can I ask you sort of a gating question for us?
Sure.
I know the question of mootness came up, and it effectively fell to the panel to decide that. So let me ask you, in a situation where, as I understand it, the bankruptcy case has been dismissed, correct?
That's correct, Your Honor.
Was that appealed?
No, it was
No,
not.
I mean, that was, okay, so that's done. And this concerns what would have been required either under a proof of claim or treatment under a plan, right?
Yes.
Okay, and those are pretty much arising in, aren't they?
Yes, they are, Your Honor.
How is this not moot?
Well, Your Honor, the debtor intends to file a new case. This issue is going to be...
And if they do, that can come up then, can it?
Yes, but then we're going to have a new set of objections to the claim and the same issue. And frankly,
But I know what you'd like to have practically be done. But is this a jurisdictional question of its mootness?
No, the issue, Your Honor, is whether the court can render effective relief.
And if we can't, the matter is moot. And then do we lack jurisdiction and we should dismiss?
If you cannot render effective relief, yes, the matter is moot.
Okay. I mean, tell me further why it isn't moot.
Well, Your Honor, this issue between the parties as to whether effective relief can be granted, it can be granted in two separate.
Let me ask you, in your research and thinking about this, did you happen to look at United States versus Patullo? Because it's strikingly similar.
No, Your Honor, I did not.
Okay, why don't we just move on? I mean, if there's anything else you want to say about this, I'm all ears, but...
Yes, there is, Your Honor. Essentially, it's not moot because the court can render effective relief in that...
But not in this case, correct? Not in this dispute. And there's no new case yet, correct?
There's no new case yet.
Okay.
There's no new case yet. However, as a practical matter, this issue is going to need to be resolved between the parties in some form. And
I mean, my reading of Patullo is that's exactly what the Ninth Circuit said. We realize it might be helpful and practical, but if it's moot, it's moot. We have no business ruling in the matter.
I understand, Your Honor.
Okay, but I know you want to get to the merits, so I've detained you long enough. Sorry.
No, that's quite all right, Your Honor. One last point on that. Essentially, this issue is needed to be resolved between the parties. The court can provide relief in resolving this issue. So, relief to the parties. So, in that regard, it's not moot.
I have one more question on the mootness part, and I'm sorry to detain you on that, but let's assume for the moment that she doesn't file another case. Are there any circumstances in which this issue, whether these fees have to be added at the back end of the loan or are due now, is there any circumstance outside of bankruptcy where that has legal significance?
Yes, Your Honor. Essentially, whether or not the fees have to be paid at the end of the loan with interest to the end of the loan, or whether the loan will be recalculated and raise or increase the monthly payment.
Well, following up on Judge Ferris's question, let's just say there were a notice of default and it were to include the attorney's fees. Would your argument be that's a faulty notice of default?
Yes. Yes.
Okay,
Because
so your argument would be that a cure on a notice of default need not include the attorney's fees.
Correct. It need not include the attorney's fees because the note in paragraph 7 provides what a default is, and it's failure to pay the regular monthly the monthly payments. So I think a notice of default that included payments that should have been on the principal would be faulty.
What happens, I mean, you're resting on paragraph 7 of the note, and I understand that, but doesn't the note also say that these attorney's fees are, I'm paraphrasing, not quoting, are due and payable when notice is given?
When notice is given or at the end of the note. However, they didn't
Well,
really
where does it say at the end of the note?
It says it shall be added to the principal. It should be added to the principal and
paid on demand.
paid on demand.
Okay. I mean, my sense is that we're not going to agree on what demand means. To me, that means paid, when asked, as opposed to paid or not paid. Because your theory is paid or not paid, right? Which doesn't make any sense to me.
Part of the problem is whether there was in fact a demand. One would think that.
Yeah, that didn't come up in the argument from which we're having this appeal, correct?
Yes, Your Honor.
It did not. Okay, thanks.
But suppose the lender were to make a demand today. The lender were to say, you owe us $7,000 or whatever it was in attorney's fees. Pay that now. Would you still be arguing that those fees could be added to the back end of the note, or are they due and payable now?
I probably would not make that argument. I think that, unfortunately, we don't have such a letter or a demand, and so they should have gone on to the principal of this. Because
going back to mootness, if I'm struggling here because I just don't see any way this issue ever comes up again in a new case. Because given your position, even if you file a new bankruptcy, I kind of think everything that's been happening here is a demand. I mean, they've made pretty clear they want to be paid. So I have a hard time seeing that in a new bankruptcy, you're going to be successful in avoiding this payment. If he hasn't sent the letter, he probably will a nanosecond after we get done with this argument. I mean,
yes, Your Honor. I assume, although without acknowledging what the lender may or may not do, but I assume that they'll send such a letter. If they do send such a letter, then I'll have to propose a plan that provides for payment of the arrearages.
Well, and the fees?
I think if they send that demand, then they can properly include that in a default. But that was not done before.
Why wouldn't the proof of claim accomplish exactly the same thing?
Well, essentially, the proof of claim has two separate compartments. One, there's box 7, which asks for the total amount of the claim, and then there's box 9 on the form proof of claim that says how much are the arrearages at the date of the petition. And that's important, at least in this case, in that part of those fees are post-petition, and also 1322B provides that the plan may provide for the curing of a defaulted.
The bankruptcy court's finding was that these fees were all pre-petition, wasn't it? I'm pretty sure. Wasn't that discussed at the hearing? I think that's in the transcript.
I'm pretty sure that they were, Your Honor.
Okay.
But the appellee seemed to argue that part of the fees were post-petition. So
okay,
not exactly clear because the state court judgment was rendered, I think, after the filing of the case. The final judgment was rendered.
But that was just a declaration of here's what was incurred prior to the commencement of the case, right? The state court was indifferent as to whether it was pre or post the petition.
Yes,
when they ruled, it's, well, here's what had happened historically, here's the value of it. Correct?
Correct. And I think the parties stipulated to relief so that the court could enter.
Right. Right. Okay.
Okay, do you want to reserve? I'm sorry, go ahead. I didn't mean to interrupt. You can reserve the rest of the time if you want, or go ahead. It's up to you.
I'll reserve.
Okay. All right, Mr. Cooper, please go ahead.
Good morning, and may it please the court. I do think that this case is moot. Anything that would be given now would be advisory, and in a new bankruptcy case, we'd be going on a different set of facts. As Your Honors noted, but we can go out and go serve another demand for payment of attorney's fees, and then this would be in a different, or at least ostensibly a different, factual scenario.
Do you concede that you haven't given it already through the proof of claim and through this process?
We do not. We did. My clients did demand it, both in reinstatement quotes and in their monthly statements. We have a very large page range of the additional excerpts of record 157 to 286. Just within there, you can go through the monthly statements and see attorney's fees.
And I will note that in the transcript from the hearing, it was somewhat striking that the debtor didn't seem to bring this up, and your client did. I mean, there was a colloquy with the court about the notice issue, as I remember, right?
Yes, and the bankruptcy court is entitled to clear error on that issue. And I think that's well supported in the record that there was a demand before the bankruptcy was filed in order to make these due and payable, and therefore properly included within the pre-petition claim. With respect to sort of what happens to the attorney's fees, counsel raised note section 7 today. That wasn't really the basis below. That wasn't the basis for the attorney's fees. Generally, they're added under the deed of trust. And the language there says it's added to, it just becomes additional debt. There is no language in the deed of trust or even in the note that says this is additional principal. It's just additional debt payable on demand. And so I don't see any basis either in statute or contractual interpretation or in the cases that we've cited to add this to the principal balance.
Well, and the purpose of the preventive language is to make sure there's no doubt but that it becomes debt. You don't have to sue separately for it, and there's no ambiguity about the interest rate and blah, 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 right? That's the idea? Okay.
Correct. Otherwise, I think Your Honors have touched upon the points I wanted to raise. I'm happy to take questions or just see the rest of my time.
I have a question about the argument that the proof of claim could serve as the demand under the loan documents. Wouldn't that mean that the proof of claim changes the status quo that existed at the petition date? In other words, it makes something due as part of the pre-petition arrearage? And if that's the case, doesn't that suggest that, oddly enough, the proof of claim kind of violates the automatic stay?
I don't think that the proof of claim changes anything. Everything was in monthly statements and demanded pre-petition. The proof of claim is just they're saying, hey, this is what happened. So I don't think it's changing anything. I don't think it's asking for monies that weren't due pre-petition. It's just giving notice.
Well, if hypothetically you filed a claim the day after the case were filed, and at that point you knew the amount of the default, but you didn't know the amount of the attorney's fees, you could have left the second piece blank and amended, right?
Yes.
The other point you're making is more important, that there was a whole separate notice here, and I think Judge Ferris's question is a really good one because it's not entirely clear what the function of the proof of claim here would be. But your point is, look, in any event, there were frequent notices and there were contemporaneous notices, right?
Correct.
Okay.
Correct. And they were cumulative. So the very last monthly statement before the bankruptcy filed it includes all attorney's fees up until that point.
More questions for Mr. Cooper?
Not for me. Thank you very much.
Okay, thank you, sir. We'll go back to Mr. Furman.
Thank you, Your Honors. The proof of claim is a critical element because if you look carefully at the proof of claim, there's one, the total amount that's due, and then secondly, it's the amount necessary to cure the default on the date of the petition. That's the exact language in box 9 of the proof of claim, and that's what we're really talking about here, is that the amount of necessary to cure the default on the date of the petition. And so certainly post-petition fees would be affected by that language, and we're looking for in the proof of claim and also in your plan the amount that it's going to take to cure the arrear, just so that you can see if you have a feasible plan.
Mm-hmm.
So that's of critical importance. Also, the demand, I mean, just because you put in an informational statement that these are fees are charged, that at least to an average debtor is a different thing than a letter that says, pay us this amount of money per the note, or we're going to record a notice of default. They didn't do that. These were informational at best, and they were not even finalized in amount until after the petition was filed.
Well, I mean, ironically enough, that's all the more reason why this is moot, isn't it? Because of the particulars you're raising right now?
No, Your Honor, because I still think the court can render relief to the parties to tell them the proper amount that should have been included in this claim and where they should have been applied.
In a case that's been dismissed.
Yes, Your Honor, although even though the case has been dismissed, potentially we could make a motion to vacate the dismissal. It would make more sense probably to file a new case, but certainly we could make a motion to vacate that dismissal. The amount that was short in plan payments was under $1,000 on the date that the court dismissed it. And of course, the court's ruling would be integral to
and that would be a Rule 60 motion?
Yes, Your Honor.
What would be your basis for Rule 60 relief?
Either for other reasons under 6 to provide relief, and for mistake, inadvertence, excusable neglect for the debtor to mistake the amount that was actually due, given that at the time there was at least $40,000 that had been paid into the plan, that it was under $1,000 short, and the plan payment had changed, would be in fact probably a mistake, inadvertence, or excusable neglect, particularly under the Pioneer standard.
Okay.
Okay.
All right. Any more questions?
Not for
Okay,
me.
thank you very much.
Thank you.
Thank you.
The matter is submitted. Thank you.
Thank you, Your Honor.